trial, or the day before trial, but basically the night before trial, saying that Mr. Bruno intends to provide his mental health experts with additional materials. We find that very troubling, inappropriate, because the experts' opinions have been given literally almost 4 years ago in their reports, and to have them review and consider other matters at this late date would result in them, we would be entitled to a report, a supplemental report, and we would be entitled to, if necessary, if we felt it necessary, to obtain the services of our own expert. We have not done that, and that should have been apparent over the many years this case has been pending. That was a decision made based upon the law and the reports that we received. And to cut to the chase, we have never meant to, nor do we intend to contest that Mr. Reinking suffers from what is determined to be a severe mental illness. It's the second part of the 501 TCA 39-12501, the insanity defense, the wrongfulness. And one of the reasons we gave Your Honor the report, so you could review it and see what was coming, but just a brief excerpt. We intend, expect, and intend, whether the defense calls him or the state does, one just really got a little thing, Dr. Kovach, on October the 2nd, 2018, in his written report, says his mental state at the time of his charges, i.e. at the time of the commission of the offenses, is looking more and more like he had an appreciation of the wrongfulness of his criminal actions, but was acting out of revenge. There is not a compelling basis for lacking appreciation of the wrongfulness, so on and so on. With that, state's position is defense cannot prove by clear and convincing evidence, so on and so on. But if we are here at the morning of trial with experts being allowed to be provided additional materials, then the trial essentially cannot go forward if Your Honor allows that to be done. And I will say, we met, and all 6 attorneys, I guess I should say 6 out of the 7 attorneys, met with Dr. Wood on January 11th. The 6 of us got together, met with her, discussed.
January 11th.
January 11th of this year.
This year.
Yes, 2022. Out at her office. Dr. Brown was also there, Dr. Kimberly Brown. And it was discussed at that time with counsel, we thought, agreed, that no experts would be provided any additional materials without the agreement of both parties. And that was done, that has been done. And we found that with Dr. Eisen had not reviewed all of the materials that had been sent to her some years ago. And again, we agreed that that was fine, as between the parties, that she could go ahead and review the ones that she omitted or did not consider prior to giving her report, doing her written report.
None of which are on this list?
Correct. They're referred to as intended to be provided to Dr. Wood. I believe that's referenced the journal. That's what we call it, the journal. But there are quite a few entries there. General Norman and I met with Dr. Kovach January the 12th at his office for a couple of hours. So apparently they do not intend to ask Dr. Kovach to review anything else, and certainly understand why. But that creates a significant problem. And as you can see from General Norman's email, once she and I discussed this last night, so, Bruno, please hold off until we can present this matter to the court. We want this trial to go forward more than anyone can imagine. and I'm sure the court does as well.
Absolutely.
Absolutely. And we want it to go forward, but it being a fair trial for the state of Tennessee and a fair trial for Mr. Reinking. We feel like we have done everything in our power as required by law to give Mr. Reinking a fair trial. But here at the last minute, bringing this up, and this was something that could have been discussed, I submit, last Monday when we filed the motion in limine, which was directed essentially to this area, or a couple of motions in limine to get anything out of the way that could be a problem. You know, the Wise case, which says, be a good idea to meet with the judge and go over everything. Well, we were here. And counsel says, we have no problem, we have no objections, we intend to follow the law and don't have a problem with it. So we forge on ahead, pick the jury, and there's no mention until last night. The defense saying following videos may be played, that I submit is perhaps another issue which goes into Rule 703. If the experts have viewed them, then we get into all of the, whether it's admissible, the court would have to do a screening process about that. If they intend to just play these, I guess we'll have to see how that works out, but there would have to be relevant statement by a party opponent, if that's what we get into. There's all sorts of evidentiary issues before we get to that, of them just saying, well, Judge, we're popping in another video, and it has to be relevant to a contested issue. And we're talking about, I think I don't know if you can correct me, but my impression is that all of these videos were created prior to the commission of the offense and not on the date of the commission of the offense. So they have been in existence for years. They have been known to counsel, I would submit, for years. This is, as far as being a non-contested issue, to the extent that would go towards whether he was suffering from a severe mental illness, it may require the jury out here when we get to that point. But the more concerning is that when he says Dr. Wood and Dr. Eisen will be provided copies in the morning, would ask that if the defense feels that this is something that is so important to their case, to have the doctors review these when they've had years of opportunity to do that, that would result in either or both preparing supplemental reports. And then we get into, like I said, to start with, all of that issues. We needed to bring this to the court's attention, obviously, before the jury is sworn, because this impinges on the state's right to a fair trial, Smith, and should not be allowed. And with respect to Dr. Wood, and again, the contested issue part of the severe mental illness, the schizophrenia, Dr. Wood, and this was also part of the motion in limine, as Your Honor knows from reviewing the report, deferred the insanity evaluation on June 12, 2018 to MTMHI. So she, I submit, cannot now testify about anything dealing with that. She deferred the opinion on that. That's in the record of the documents provided to Your Honor. And so insofar as giving her any information, we think that would be, again, irrelevant unless they're going to try to have her, again, do a supplemental report to address an issue which she deferred. So for all those reasons, submit that none of this should be allowed, and we can deal with the playing of the GoPro things as that comes up, because the state's not going to do that in our case in chief. But just to be on notice that we would object to any of that coming in. Obviously, they'll have to lay a foundation, so on and so on. But the more concerning part at this moment is, are the experts going to be allowed to supplement their knowledge and or information? And if so, the state's entitled to a supplemental report and a review of that, and not swear the jury until that is done. However many days, months, weeks that might take. May I have a moment, Your Honor? Thank you, Your Honor.
All right. Mr. Bruno?
So, Your Honor, I appreciate Mr. Moore's position. There was one thing that was never mentioned in his statement, and that is anything dealing with the law. So I'd like to start mine out with the law. Rule 703, basis of opinion testimony by experts, says the facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to the expert at or before the hearing, which would be the trial. So the expert can testify about anything at or before the hearing. The expert could come in here, watch this entire trial, and anything that comes up in the middle of this trial can be used, if it's relevant to their opinions, when they take the stand. They can discuss it. There is no rule that says that there is a direct cutoff of when an expert can be supplied with information, except until they basically finish their testimony. Quite frankly, an expert can be on the stand and can be shown something that they've never seen before, and ask them if that would affect their opinion one way or the other. So the law, that's what I'm basing my argument on, states that we can give them this additional information. The information that we want to provide to the expert is that there's a number of videos that basically come from two sources. The majority of them come from electronics that were seized from Mr. Reinking's apartment. Okay, so it's in discovery. The state's had it. This is nothing new. There are some that were downloaded off of YouTube by a man named Gene Flederer, who is, my understanding, Mr. Reinking's uncle. And he's a witness, a potential witness in this particular case. The videos, in a nutshell, basically are videos of Mr. Reinking videoing himself and discussing what's going on in his mind and his head and his paranoia, things along those lines. It's basically delusional type stuff that would support schizophrenia, for lack of a better word. So that's the subject of it. There's a journal that Mr. Reinking had typed prior to the arrest, fairly lengthy, that was provided by the state to Dr. Eisen, who's the expert for MTMHI. It was not provided to Dr. Wood. So that's the journal part of this would go to Dr. Wood. These are items that could directly impact their opinions in this particular case, one way or the other. They can get it by us providing it to them, just like we could provide anything else over the past 4 years to them for them to consider. Alternatively, and I think it's much more inefficient, they can both sit here in this front row during this entire trial and watch evidence come in, and we can, assuming it's admissible, play videos and stuff along those lines, and they can factor that in. So there's nothing that's inappropriate about us continuing to provide something. Quite frankly, if something happened today in this trial that would affect their opinions potentially, I can provide it to them tonight. So I don't, the law is on our side with the disclosure. Now, when it comes to this agreement, the agreement was not, I will ask the state for permission about what I can give to the experts. The agreement, both sides wanted to know everything that the experts had. Okay, we wanted to know everything that they reviewed. The agreement was, if one side sent something to an expert, we would let the state have the copy, or if they sent something to an expert, they would let us have it, so that everybody knows what the experts have. There wouldn't be any backdoor giving the experts information that the other side's not aware the expert has in the case. So
But
it wasn't,
but at this stage of the game, and I understand your 703 argument, but at this stage of the game, isn't it sort of backdooring?
it's not backdooring because as we're prepping this case and we continue to go through stuff and what might be coming in evidence, what we might want to be putting in evidence, is we click something that we think might be appropriate for them to consider in their testimony, then we can give it to them. Just like if we sit here in trial, let's say Wednesday, something happens in this trial that is relevant, we're going to send it to them.
Why wasn't the material provided earlier, since it was available earlier to the experts?
We hadn't, quite frankly, we hadn't gone, there are so many videos in this case, we hadn't gone through all of the videos and then narrowed it down to what we thought might be most relevant until last week and this weekend. That's why yesterday we finished our discussions over what we thought might be most relevant to their information, might be most relevant to their opinions in the case. The state has had, almost all of them the state has had, so that it's not like they're not aware that they exist or the substance of them. But
What is your position on the state's argument that if this material, and I have no idea what's in it, I mean, you gave me a summation, has to deal with possible delusional behaviors, the thought processes before this event that brings us here today. That's what I know about him. What about the state's position that we prepare for trial based on this is what the experts are likely to testify to, and with the addition of this, it may change their arguments, and we may want to get our own rebuttal expert?
I don't know how, the substance of it is, so we'll start with this. All those materials, okay, what Mr. Moore was referring to, I think he made a statement somewhat to the effect, they go to a non-contested issue, in his opinion, which is schizophrenia, okay? If it's a non-contested issue on their end, I don't know why they would need to run out and get another expert.
Well, because I don't think the issue in this case is that he has a severe mental disease or defect. It's the concept. It's what, if any, effect that had on his behaviors on this occasion.
Yeah, right. So that's why I don't think there's a need to go out to get a rebuttal expert, because those issues would go towards the schizophrenia issues.
That's contained.
There's a couple that are close in time, a couple of weeks before or so the incident. It gets closer in, and so, but a majority of them are things that happen over a period of time. But again, it goes to it's an issue dealing with more towards the schizophrenia, that part of it. So if it's generally a non-contested issue, why would they have a need to go get another expert? There's no need to get a rebuttal expert if they're not in effect contesting that part of the issue.
Then what's the need to even bring them up at this stage of the proceeding?
Because we have a burden of proof.
But if it's, it seems like you're talking out both sides of your mouth. It's going to an uncontested issue, but we needed to prove our insanity defense.
Okay, I'll give you this example. We're not disputing that Travis Reinking went to Waffle House, shot, killed 4 people, and injured 2 other people, okay? Can we just have an agreement the state doesn't put on any proof of that because we're not disputing it? It's uncontested. You know, if we want to go down to if it's not contested, then we can get rid of a lot of their proof because it's not contested, and we might be done with this trial in 2 days.
That would be wonderful, but that's not a reality.
But it's the same thing for us. We have a burden, and even if they're not going to contest it, we have a burden to put on our proof.
So are you suggesting that whatever is in these, and again, I have no idea, whatever is in these videos, journals, whatever the case may be, will have no bearing whatsoever on the ultimate issue in this case as to whether or not he could appreciate the wrongfulness of his conduct?
I want to be real exact about it because
that's what I'm trying to get to, exact as possible.
He thinks in the videos, okay, he thinks that people are after him. He's paranoid of the government. He's paranoid of the police. He's paranoid of certain people, okay? that feeds into the appreciation of wrongfulness, because that's generally what's going on. But most of it is going to be, they're going to basically see the videos and see this guy's not right, okay? But there is language about people hacking into his phone and doing things to him, and that, along with other evidence that the experts have, that might go to, them saying he was thinking people were after him, and so that might go towards that prong to some extent. Because and so I couldn't, and quite frankly, the experts, there's a couple of videos that's already been provided to them by Mr. Wing. It's not an issue, but they haven't looked at the others. So, but our belief is that the primary thing, because most of this stuff happens substantially before the Waffle House incident. These are things that he's going through in Colorado or Illinois or things like that. But then some of it does get close in time to where he's talking about his paranoid thoughts. I don't recall, and they can correct me if there's anything on there that specifically says people at the Waffle House. I don't remember if there's any of that on there, but so I mean, I guess it could lead over into this, his paranoia, and so I guess experts might say, well, that just further supports their position in the case.
All right, thank you.
Very briefly, I think I did reference the law, Rule 703, but with respect to expert reports that we are entitled to, that comes, of course, from State v. Reed.
Very familiar with Reed.
Yes.
My colleague mercilessly went through that for many years.
Yes. So that's what a reference supplemental report can't just say, oh, the state's called unawares that we've been given some other things and this does now enhance, or here's why I have a belief even more strongly an opinion that he could not appreciate the wrongfulness of his conduct based on these videos that I've viewed. That is, and yes, with respect to Rule 703, facts or data otherwise inadmissible shall not be disclosed to the jury, so on and so on. We get into that only after, if they are allowed to supplement their understanding and their materials, we would be entitled under State v. Reed to a supplemental report, not be essentially caught unawares or sandbagged by having an expert on the stand who has reviewed materials and is changing perhaps their report, their opinions, without us having an opportunity pre-trial. That's the key, before the jury is sworn, pre-trial, to evaluate that. Therein lies the problem.
I disagree that there is a continuing, every time they get something new, have to do a supplemental report. If that were the case, if they're sitting in here and tomorrow these videos come in and they say that would affect our opinion, they don't have to go back to the office and do a supplemental report. So that's not where we're at with this. And what if we on cross-examination, they get shown something they've never seen before? Would that affect your opinion? Do we stop and they go do a supplemental report? No. So that's not, there's this supplemental report thing is not the issue in the case. Okay, they can consider up until they finish testifying, anything that's presented to them, that the court allows to be presented to them, they can consider that.
But I understand that part of the argument, but I'm still a little bit concerned that all this material has been available for years and was not presented to these experts. Rule 16 on the discovery rules certainly suggests that is the appropriate procedures to follow during discovery. And I understand that an expert can sit in, listen to testimony, and go, I had no idea about that, or I didn't understand the significance of that, or just how, no one ever told me these statements were made or conduct exhibited on this particular occasion when this incident occurred that they didn't know and it reasonably would not have been expected to be presented to them. But when you're talking about a significant amount of material that obviously could influence an expert opinion, why it wasn't provided much earlier under rules of discovery. What they hear during the course of the trial and things that may come up during the course of the trial or immediately leading up to it, I'm not disputing they might be able to, that they could possibly rely on under 703, but when you have all of this massive amount of materials that has been in existence forever and wasn't provided to them, I don't think that is the same as what you're arguing here. I agree that things come up during the course of the trial that may influence how an expert looks at things and are not required to go back and type a report. But when they have ample opportunity to review and consider thoroughly, fully, and as a part of their reports that are required under Rule 16, why it wasn't done. Why is it just now coming up? This isn't something that they're sitting in trial and they might hear and they go, oh my gosh, I didn't know about that. I need to change my thought process.
So I don't know if it's a Rule 16 issue, because that's our obligation to give things to the state, discovery things to the state. I don't think that's the obligation that goes towards what we have to provide an expert in advance. So let's say the court's going down this road. Then in the middle of the trial, if we get these videos into evidence at that point, then I don't know of any reason why an expert can't look at it at that particular time. Now, what that's going to do potentially is they have time to look at it. So what that might do is, as they come in, and then we tell the court we want to give that to the expert, they have to have time to review it. And what I'm trying to do is cut that off, give it to them today, so that when it comes time for them to testify, they've reviewed it. So I don't think 703 prevents us from giving them additional information of whatever we find. If we continue to go through discovery or files or whatever else, and we find something else that we think is relevant to our issue, we can give it to them because they haven't testified yet. And that's all we're trying to do with it. And it also makes things more efficient. So I think Rule 7.
Well, it'd been more efficient if they had it 3 years ago, rather than the morning of trial.
I agree with that, but they didn't. And so, but nevertheless, Rule 703 allows us to provide the information.
That was a choice the defense made, whether that's by strategy, that this was a plan 3 years ago to do this or not. I have no way of knowing, obviously, other than they said they can make everything he said at his word that they're going through this. But that begs the question of why so late?
Well, that's what I was trying to get to.
Absolutely, absolutely. And why now? Why the morning of trial? As opposed to, yes, we'll have Dr. Eisen come sit through all of the testimony and see what is introduced. Now, they want to send her things that may well not be introduced for all the other reasons that I've said. That's where the problem lies. And if she has days, weeks to go over that, and we're certainly going to be rather busy to be able to speak with her. And yes, I agree. If something that comes out in court, that's not what they're wanting to do. They're wanting to send her a ton of materials literally after the jury's been sworn and jeopardy is attached. And that's not fair.
No. Anything else?
It's not about fair. It's about the rules. It's about the rules. And so the other way this stuff could happen, and fine, we have all the time in the world, but the other way this stuff could happen is they could cross-examine an expert, and then we could start pulling these out. And there's a roughly 250-page journal that's typewritten that might be handed to an expert at that point, and she can take whatever time she needs to read it on a redirect after a cross-examination. So, all of this stuff is relevant to the issue, to our burden of proof. We haven't Under the rule, we're allowed to do it. And, you know, if that's the way we prefer to do it, because that is the way that's going to make this thing most efficient, but we have all the time in the world. And if we have to do it another way, so be it. But I don't think that we've done anything but follow what the rule provides. And so I think we're in the right place.
May have followed the letter of the rule. I'm not sure that you've followed the spirit of the rule. But give me about 10 minutes and I'll get back with you.